And excellent. So first of all, ACEC Colorado seeks to avoid antitrust violations in connection with its activities. So therefore, please avoid from engaging in conduct that gives even the appearance of impermissible conversation, agreement, alliance, or impropriety. Discussions among all participants must be kept free of even the suggestion of restraint of trade or the selection of suppliers, customers, or prices. That protects all of us, frankly. After the program, you'll be sent an email message with an evaluation and a link to the reference materials for this session. To get the credit, you must have your full name typed into your Zoom profile today so staff can verify your attendance. Please double check that now and rename yourself if needed. To do that, click on the participant's icon at the window, hover over your mouse over your name, and then click Rename button. Use the chat feature if you need any assistance from our staff during the program today. We'll also monitor questions in the group in the chat, so please feel free to enter your questions there, and our presenters will try to address them as we go. I also want to thank our corporate sponsors who support greatly helps ACEC Colorado to provide its programming. A special thank you to our Diamond corporate sponsors, Initial IT, Ken's Print and Graphics, and USI Insurance Brokers. Everyone attending today will receive one professional development hour that will be reported to the Registered Continuing Education Program for Engineering, RESAP. You'll receive an email within the week with information to access your credit. So now we'll go ahead and get started and launch into our program. So today we're going to be talking about workers' compensation. Purchasing workers' compensation insurance is only the first step in protecting your employees and your bottom line from workplace injuries. This session will be build upon basic understandings of workers' compensation by discussing common mistakes in acquiring coverage, how to go above and beyond for workers following an injury, and case studies that establish relevant legal precedents for employers and human resource leaders. Today's workshop is being led by two representatives from the Colorado Department of Labor and Employment, Division of Workers' Compensation. Alex Reynolds is a content strategist for insurance and employer programs, and Joel Cummings is supervisor for coverage enforcement. Welcome, Alex and Joel. I'll turn it over to you to start today's program.
All right, thank you so much, Stephanie. I will just take a second to share my screen. We can get the slideshow up. Okay.
Excellent. Hopefully everybody can see those slides and we're ready to roll.
Absolutely. And yeah, if you have any difficulties with seeing the slides, or if you, like we said, if you have questions, go ahead and feel free to throw them in the chat throughout. We'll also have some time at the end. And yes, Stephanie said it all during the introduction. We are from the Colorado Division of Workers' Compensation. For those who may not know, that is a state agency that regulates and oversees insurance carriers, employers, injured workers, and healthcare providers. We don't award benefits or sell policies. Our goal is simply to facilitate a fair and effective system for all of the individuals and entities involved. And the topic for today's presentation, as was mentioned, is about protecting your business and empowering your employees. We are going to go beyond that basic level of understanding to talk about really how the details, the day-to-day operations of how you manage your business can have a huge impact on what happens after a workplace injury in terms of protecting your business, your employees, or potentially being exposed to risk. So that's really the main topic that we're going to discuss. We've done the introduction, so we'll go right into the agenda. We'll start with a quick overview of workers' compensation basics, just to set the stage. From there, we'll discuss unique employment situations, such as contracting, which can often cause misunderstandings about workers' comp requirements, and as a result, breakdowns in coverage that can cost workers and employers. So we'll look at one case in particular for that called Pella Windows, which illustrates really the complexities of defining the employer and employee relationships and why that matters. Next, we'll look at another common blind spot for businesses known as the statutory employer principle. MDR roofing is the case that we'll discuss for that concept and that topic, and again, why it matters for you. Finally, we'll wrap up with a review of best practices following an injury and look ahead to some other useful information. We have a great workplace safety program, completely free, that we're really proud of here at the division. It offers resources and industry support for risk management and implementing and maintaining a really excellent safety program. It also can get you savings on your premiums, direct discount. So we'll talk a little bit about that and look ahead to, we know what to do on a day-to-day basis, but if an injury does happen, or really how do we address safety directly? So the most basic question that one might ask when starting to think about workers' compensation, well, what is it? Right? So how do we define workers' compensation insurance? Put simply, workers' compensation insurance provides medical treatment, lost wage benefits, and permanent disability benefits to workers who are injured on the job. Our website is linked there. There's a lot of great resources. That page in particular is probably the best place for y'all to start as employers. But we'll have a few different links throughout the presentation with the slides that I think should have been provided or will be provided afterwards. So definitely encourage you to look through and see everything we have. But like I said, we have a few different important links that we'll share with you and that are present in the slide deck. All right. So, getting ahead of myself. All right, so we know, what workers' compensation insurance is, but defining who specifically needs it, right? So according to Colorado law, all businesses with employees operating in Colorado must have workers' compensation insurance. And again, that's the definition there, with employees operating in Colorado. So that is different than saying that has a presence in Colorado or that has locations in Colorado. Doesn't even mean that the employee has to live in Colorado necessarily. So employees operating in Colorado must have workers' compensation insurance. Any exceptions to this rule are highly specific, and that is a lot of what we'll discuss today. One of the takeaways from this presentation, sort of like a mantra maybe for the morning, is that generally it is worthwhile to consult an attorney, insurance agent, or similar professional specialized in workers' compensation in Colorado to ensure that you're fully covering your business and your workers. And to talk a little bit more about why that usually makes sense, I will now pass it over to Joel.
All right. Thank you, Alex. And thank you all for having me today. So as Alex mentioned, the requirement for workers' compensation is pretty basic. Anyone with one or more employees in Colorado must have it. And as Alex said, it's always worthwhile to consult a professional. And one of the major reasons is that there are costs associated with not carrying insurance. As Stephanie noted earlier, I supervise the coverage enforcement unit. Besides doing things with Alex and the outreach team to preemptively educate businesses, we also investigate businesses and we impose fines. And so anytime we investigate a business that's either misclassifying their workers or failing to carry workers' compensation, we are required to impose fines by statute, and those can go up to $500 a day. So that is one of the costs. Is the potential for fines for failing to comply. But even more than that is the cost of an uninsured claim. If a worker is injured and the business is not insured, the business is liable to pay for all costs of the claim out of pocket, being medical costs, lost wage costs, permanent disability costs. Our stats show that the average cost of a claim is $10,000. Which certainly exceeds the cost of most of our investigations. And then, as is common in the construction industry, severe claims, which would be permanently totally disabled, meaning the worker can never work again, or a fatal claim, those can approach $500,000 in the average cost. So the cost to the business is paying for claims out of pocket, being fined, and certainly the cost to the employee. If there isn't coverage, that makes it more difficult for them to get medical care, for them to receive wage replacement, for them to get the kind of treatment that will prevent long-term disability, which will affect their ability to provide for their families, both in the short term and in the long term. So we do have a few cases that we do want to go over to talk about the importance of insurance and some of the complexities around making sure that you're properly insured and that you're defining working relationships correctly. And again, these are all about how you can protect your business and your workers. So now that we've talked about the gaps in coverage and the consequences for workers, we're going to really look at two common issues, which Alex alluded to earlier. The first is a proper definition of the employer-worker relationship, and making sure that that is defined correctly, that the terms of the contract are correct, that the actual working relationship is correct. And then the second is what we call the statutory employer principle, which will expand who is liable for a claim, and it will expand what the definition of an employer is. And I appreciate that you are all here today to learn. It shows that you are interested in understanding workers' comp at a deeper level and protecting your business. So the first thing that we want to look at is the employer-employee relationship, or often what we call the contractor versus employee relationship. In statute, the legal assumption is that anybody who is providing services for another for pay is deemed an employee. So that is that's the baseline understanding, is if you're paying someone for work, they're considered an employee. And what that means is that if you want to demonstrate that they're not an employee, but a contractor, the burden is on the employing entity or the business to prove that they're not an employee. Now, I have to say this, and we'll say this throughout, every situation is different. So this certainly isn't legal advice. We just want to go through what the statute tells us, what the courts have told us. And as Alex mentioned before, it's always best practice to reach out to a work comp professional, whether that be an accountant, an agent, or an attorney, to make sure that you're in compliance. But two ways that we determine the working relationship is first the two-prong test, which is the standard for if somebody is an employee or a contractor. And then the statute also gives us 9 factors, which help us to clarify where things stand in that initial two-prong test. In these two cases that we'll be looking at, both of them went to the courts. One went to the Court of Appeals, and the other went to the Colorado Supreme Court. As you'll see, in one case, the business won, in one case, the business lost. But in both cases, it was a long, drawn-out process. Certainly took an emotional toll on both the worker and the employer, a financial toll, a time-related toll. So our hope is that through this presentation, you'll have the tools and the empowerment to make sure that you're making the right decisions, so that even if you win on a claim, you don't have to deal with all of this other stuff of going through the legal process. So the first test that we have is the two-prong test. And as I said, this is really the baseline. Everything else points to this. But the two prongs for demonstrating that somebody is an contractor versus versus an employee are first that they must be free from direction and control in the performance of their service. And essentially the idea behind this prong is that if they're an independent contractor, that should indicate that they are an expert at their trade. And so they shouldn't have to be trained on how to do it. Tools shouldn't be provided. They shouldn't need to be supervised. They should be able to do this job based on their experience and their expertise. The second prong is that the worker must also be engaged in an independent business related to the service being performed. And once again, the idea is that if this is truly an independent contractor, then they are basically running their own business. And so they should be offering their services to multiple entities. Now, again, this is a two-prong test, and it's not an either-or test. It's a both-and test. So they need to be free from direction and control, and they need to be operating their own business. Now, the statute does offer 9 criteria that help us to determine if somebody is an employee or a contractor. I'm not going to focus on each of these factors here, but they are here for your reference later. But basically, they help us to determine A, the degree of direction and control that the business is exercising over the worker, and B, if the worker is operating their own business. That's why it addresses things like schedule flexibility, the provision of training, the provision of tools, how the worker is paid. Are they paid personally or to a business? Those things all help us to understand, is this worker an employee or a contractor? And I'm sure that in your experience, you can think of a number of gray areas that aren't as cut and dried as we would like to hope with the statute. You may also be wondering if there's some sort of balancing test where one of these weighs more than the others, or if 5 are in your favor and 4 aren't, what that means. And unfortunately, the statute doesn't provide that. As we've discussed before, these are all unique. And this is something you should be talking about with a professional as you draft your contracts and as you build working relationships. Now, in addition to the 9 factors in the 2-pronged test, we have a case called Soft Rock, which did actually go to the Colorado Supreme Court, and which will be part of the basis for the Pella Windows case that Alex will discuss. But in Soft Rock, the Supreme Court even expanded the types of factors we should be looking at for whether somebody is an employee or a contractor. So the court in that case was looking at things like, does the worker have their own business cards? Do they have their own business phone number? Do they have a business checking account? If there's an accident or they mess something up, are they liable for that financially? Those, again, are factors that are going into, is there direction and control, and does this individual have their own business? And one thing I do really want to stress, in addition to these prongs and these factors, is the value of a contract. Our statute is very clear in how the contract should be written, what things should be in it. It even comes down to like the certain font and type in certain parts of the contract. And so when you are drafting a contract, you want to be very sure that it is compliant with the statute. And one of the reasons for that is that if you do have a compliant contract, that shifts that burden that we talked about at the beginning. As you might remember, the underlying assumption is that somebody's an employee, but if you do have an appropriate contract in place, that does shift that burden. And then at that point, they are considered a contractor. And if there's an injury, then it becomes the worker's burden to prove that they're an employee. So it's very important that you have a well-written contract in place. But the one warning I want to give on that is that if the contract is not adhered to and the actual working relationship does not match the contract, then the real life facts are going to determine whether somebody is a worker, is a contractor or an employee. So the contract is great. It's very important that you have to be sure that you are sticking to the contract in order to ensure that you're working with a contractor versus an employee. So as we'll talk about a lot today, where businesses get in trouble is in the details of how they set up the contract, the details of how they address the working relationship. Again, sometimes businesses want to cut corners. They'll Google a contract online, maybe pick up a form that Pinnacle created that's floating around. And those things can come back to bite you if you're not doing things correctly and if you're not consulting with a professional. So far we've looked at a lot of things theoretically and statutorily, but I'm going to hand it back over to Alex to discuss a case and what that looked like in real life.
All right. Thank you, Joel. So as he mentioned, we're going to look at a case now. So the first case that we'll discuss is called Pella Windows. And here are the basic facts. So the employer, Pella Windows, laid off an entire team of 17 service technicians who were originally classified as employees. And then immediately after, they offered service contracts to 9 of them to work as independent contractors. Under those contracts, they effectively performed the same services as when they were called employees. So now 4 years into this arrangement, the worker in this case fell and suffered permanent paralysis. Several months later, they filed a workers' compensation claim against Pella. The ensuing legal battle highlights a lot of this complexity and nuance that we are referencing and kind of dancing around. And we can see how it played out in the court. So the next slide has a lot of text on it, this disclaimer. But really, I wanted to make sure these details were here for your reference moving forward. We're not going to read through each of these. But again, I encourage you to revisit it if you're interested. But the point is that there were several factors in favor of both sides. So some elements of the relationship supported Pella's position that the worker wasn't their employee. For example, kind of as we talked about the prong test, the claimant had registered his own business. But other factors supported the worker's claim that they should have been covered as an employee by Pella's workers' compensation policy. To continue on that example, even though they had registered their own business, they had never once performed work for anyone except for Pella Windows because their workload was that of a full-time employee. They didn't have time to engage as an outside business. So now, as we discussed, the situation is messy, it's complicated, and it comes down to the courts and the people within the courts to try to make sense and make a determination as to what should happen. So how did that go? Joel mentioned, that there was a lengthy court process, and that certainly was the case. So again, I encourage you to revisit this if you're interested. But to sum it up, the original ruling favored Pella, with the judge deciding that the worker was in fact an independent contractor and responsible for his own coverage. So that was appealed. A panel of judges rejected that decision and says, well, you need to look at the total relationship, not just the 9 factors. Again, as Joel mentioned, with other precedents that have been set. So that judge reconsiders again with all of the total working relationship considered, and still decides to rule in favor of Pella Windows. So this time, the panel just disagrees outright and says, no, we are going to award the worker benefits. And finally, and again, this is years in the making, after a higher court, the Court of Appeals, decides that the panel had overstepped their authority. They go back to the original judge's ruling in favor of Pella. And if that feels like a lot of back and forth, that's kind of the point, right? The different courts and judges come to different conclusions. And in the end, it's a matter of who has the authority to make the decision that ends up being the final sort of period on the sentence, right? That's how the whole thing gets settled is, well, let's see who has authority, because you have different groups who are disagreeing about what should happen with this decision. But, what are the takeaways, right? Because I don't want to sit here and make it sound like we're telling you that everything is out of your control and really you're at the mercy of the courts with no power to do anything. The takeaway is that ultimately documentation and credibility helped establish stronger evidence in Pella's favor. But even though they technically won the case, like we've said, they still experienced 4 years of costly proceedings. And at the end of the day, a person still suffered a tragic accident. So in these situations, there really aren't any winners when it comes to this. So when it does come to protecting your employees and your business, the details really matter. The documentation and the diligence of how all of your work is managed, but especially contract work with any person or business, is what makes the difference. So having a policy for everyone on the payroll is a great start. But when it comes to working and business relationships, that diligence and that proactivity is really what's required to have peace of mind throughout. And so this just doesn't apply to individual contractors. We're now going to discuss a little bit about how working with other businesses can have its own set of complications. And for that, I will send it back to Joel.
All right. Thank you, Alex. Thank you for going through that case. As you might have noticed in the back and forth, there's a bit of a power struggle going on between the various courts. And again, that's not really the way the legal process should work out. But as Alex mentioned, both Pella Windows and the claimant were basically collateral damage, as the judge and the initial panel in the Court of Appeals tried to all impose their will on each other. So that's something else to remember, is that anytime you're working with attorneys and judges, there might be some ego going on, and that can lead to delays and costs. So as Alex mentioned, we're now moving beyond the independent contractor statute, and we're going to talk about the statutory employer principle. Basically, this idea is that anytime work is contracted out, the person who is doing the contracting is considered a statutory employer of the contractor and their employees. And this creates a chain of liability, as we'll see in the next case. It's not just one level, but if you contract down to somebody to do a job and then they sub out and then they sub out, this chain of liability can move up. Now, the reason for this is it's a protection for the worker. So if somebody is injured on the job and their direct employer doesn't have coverage, they are allowed to go up the chain of liability or the chain of statutory employers until they identify a business in that chain that has a workers' comp policy. At that point, that employer and their insurance company will be liable for the claim and the cost of the claim. So in that case, the worker does still get the benefits that they should and the treatment that they should, and that's a good thing. However, that's not going to look great on your experience mod. When you come to renew your insurance, you're probably going to be subject to an audit where they're going to want to review all of your contracts and all of your contractor relationships. Again, this is something that is going to cost you time and money just to provide the insurance company what they want. And then in the end, it's also going to affect your premium because the cost of that claim is going to go against your experience. So as Alex said, what's important here is understanding how you're working with these other businesses so that you are protecting yourself and keeping your premium low. Now, that's just in a situation where there is insurance at some point in the chain of liability. In the case that we'll look at next, nobody in the chain of liability had insurance. And so again, that goes back to what we talked about with the cost of failing to insure, which then means that everybody is liable to pay for the cost out of pocket. But again, as we look at the statutory employer principle, I don't want you to feel like things are out of your control or that everything is left up to the courts. Once again, we're going to look at this case and we're going to look at best practices so that you can see the importance of, number one, making sure that your policy is appropriate to protect you and those under you, making sure that when you're drafting contracts with other businesses, that you're very clear about the working relationships and about who's required to have coverage, and then making sure that you're verifying that your contractors and subs continue to maintain their coverage. So once again, you just have to make sure that you're doing the right things, that you're paying attention to the details, and that will save you time and money. So looking at this MDR contractor case. So in this case, we call it MDR Roofing. That was the name of the direct employer. I don't think that's actually the legal name if you looked it up in LexisNexis, but we always call it the MDR case at the division. But what happened is that we have a rental property owner who had hail damage to the roof of their rental property. We'll call them the employer or the property owner. And then they subbed out to a company to repair the hail damage. And we'll call that company the contractor. Now, the contractor did not have insurance, but they decided not to do the work themselves. So they subbed it out further to MDR Roofing to perform the work. Now, in this case, the property owner did not know that the original contractor was not doing the work. They were unaware that MDR had been subbed in to do the work. However, the contractor, when they brought MDR in, they did require a certificate of insurance from MDR. And the certificate of insurance did show that MDR Roofing had workers' comp insurance. So it looked like they were doing what they should under statute and like they were protecting themselves. However, this case exemplifies the downside of relying on just a certificate. Because after MDR provided that certificate to the contractor, their policy was canceled because they failed to pay the premium. Now, the contractor did not know that the policy canceled. They had received a certificate and they thought they were in the clear. And as mentioned before, the property owner didn't even know MDR was on the site. So we already have some communication errors going on here. Well, as sometimes happens, MDR's policy has been canceled and a worker falls off the roof and has some very serious injuries. MDR tries to get their coverage reinstated. They pay their past due premiums. They intentionally don't disclose the injury. And the carrier at that point does retroactively reinstate the policy. But then MDR files the claim, and of course, something doesn't add up. And so the carrier denies the injury and cancels the coverage again, stating that MDR basically lied to them to get the coverage back. So this is where the case moves from just the real life part into the legal situation. So MDR first appeals this denial of the claim. They take it to a hearing. They try to demonstrate that they had coverage, but the court rules in favor of the insurance company. Again, noting that MDR was intentional in not disclosing the injury when they tried to reinstate the policy. And so now that the direct employer, MDR, definitely does not have a policy for this injured worker, now we have a statutory employer situation where not only is MDR liable, but the claimant can go up to the contractor who doesn't have comp, and then can go up to the property owner who doesn't have comp. One thing I'll note real briefly is one thing that is a special situation here is that this was a rental property. The statute does protect homeowners who contract out for work on their residence, but because Norma Hoff, who was the owner of this rental property, was earning an income on the property, that made her liable as a statutory employer. So that is something to be aware of. But yeah, so the court says, no, there's not insurance here. The court says property owner doesn't have insurance, contractor doesn't have insurance, direct employer, MDR, doesn't have insurance. Therefore, all of you are liable for the cost of the injury. And as we mentioned before, that's medical costs, that's lost wages. If there's permanent disability, there's a cost there. If there were a fatality, which there's not in this case, that would be the cost of paying benefits to dependents until they are adults, or a dependent spouse until he or she remarries. So as we mentioned before, the cost of a claim like this is easily $500,000. And the court determined that all three parties were on the hook to split that cost a third each. So the property owner appeals this. Again, her appeal is, I didn't even know MDR was on this. I never contracted to them. The contractor also appeals this, saying, hey, I got a certificate of insurance and I was even listed as a certificate holder. I should have been notified of the cancellation. So anyway, this case goes up through the initial panel, through the Colorado Court of Appeals, and up to the Colorado Supreme Court. And the Supreme Court ultimately rules that the insurance company only has a legal obligation to notify the policyholder of the cancellation. Not certificate holders, just the policyholder. And so that's a win for the insurance company. Because otherwise, if the court had said that they needed to let the certificate holders know, then it likely would have gone back to that they needed to cover the claim. But the court said only the policyholder has to be notified. And so the insurance company didn't violate anything. However, that still didn't relieve the obligation for the property owner and the contractor, their obligation to obtain and continually verify coverage for their subs and their employees. So at the end of the day, nobody had insurance. The carrier was absolved of any responsibility. We have a seriously injured worker, and we have 3 uninsured entities that need to pay for that out of pocket. As Alex said with Pella Windows, nobody wins in this situation. So what are some lessons that we can learn from this? Well, the first is unfortunately that liability supersedes intention. The contractor, the middleman, they tried to do things the right way. They requested the certificate of insurance to demonstrate that the sub had coverage. They also requested that they be a certificate holder in the hopes that they would be notified of cancellation, which didn't work out. But they did the right thing, or they seemed to do the right thing. And even though their intention was to comply, there was one bad actor, which was MDR Roofing, and that still made them liable as well as the property owner. The second lesson here is that certificates are only a snapshot. That certificate that you receive only guarantees that there was coverage at the moment the certificate was produced or that it was printed. There is nothing that will stop a business from going back to their agent a day later, a week later, and actively canceling the policy, or as in the case with MDR Roofing, just ceasing to pay the premium. So a contract is very limited in how it protects you. However, we do have a solution for that, and that goes to our final lesson, which is being proactive and, again, focusing on the details. If you can set up a plan where you are regularly ensuring that your subs are in compliance, you will be protecting your business and your workers. So there are a few things to know, once again, that can help protect you as a statutory employer. The first thing is that you can always carry a policy that covers everybody that you hire, whether they are an employee or a contractor. They have policies called wrap-up policies, which cover a specific work site, or you can set up the policy and bring in all of the contractors onto the policy so that everybody is protected. The statute also does legally allow you to require those entities that you're contracting out to pay their portion of the policy. So in this case, you would be the policy holder, but you would be bringing everyone onto that policy, and you can charge them back their portion of the premium. That way, you're not paying for their workers' comp, but you also, as the policy holder, will get notice if the policy is canceled or pending cancellation, unlike the situation in MDR Roofing. The second way to protect yourself is, as I alluded to in the last slide, is to be actively verifying coverage, really as often as you can. And as we said, a certificate isn't really going to cut it, but we do on our website have a live database, which shows real-time information about whether a business is insured. So on this next slide here, you can see the link is there. And when you get a copy of the PDF or a copy of the slides, I would encourage you to go to that link and bookmark it. As I said, this is real-time information. So there's 3 screenshots here. You can search a business by the name of the business. You can search it by their EIN, or you can search it by their address. And it will show you, it defaults to the date of your search. So if you're searching today, it's going to default to today. And it will show you as of today whether the policy is active or whether it's canceled. Once again, this is real time, unlike a certificate of insurance. So this is a tool that will be helpful to ensure that not only is the contractor have a policy when you bring them on, but that they maintain the policy throughout the duration of the contract. Now, there are other instances where you might bring on a contractor who has no employees. They're simply owner operated. And in this case, they do have the option of rejecting coverage. And this might be the case for some of you on this call, that you don't have employees for your own businesses and you've rejected coverage. And we also have a database online where you can verify that a rejection has been formed. So again, this next slide here, you have the link there. That's something I would encourage you to check out and to bookmark. But one thing to remember is that just because a business may qualify to reject coverage, they are only owner operated and they don't have employees. So just because they can reject coverage doesn't mean that is something that automatically happens. According to our statute, they must actively do something to reject coverage, and that is to complete our rejection of coverage form submitted to the Division of Workers' Comp. And then we process it, and again, it ends up on this online database. So once again, you want to make sure that somebody has actively done that. And you're not just trusting them to say, yeah, I don't need coverage, I don't have any employees. Once again, you want to make sure that they've actually rejected coverage, because again, that is going to protect you in case there's an injury. Because that kind of works into that chain of statutory employment, where you have this case saying they actively remove themselves from the workers' comp system. Now, again, when things go to court, you can't 100% say that that's how it's going to work out, but that is a protection for you. So just like our coverage database, this rejection of coverage database is live. It's in real time. We tend to process these forms within 1 or 2 working days of receipt. So you should know if somebody has just done it, you should know that it's going to be in the database fairly quickly. And at that point, I'm going to hand this back over to Alex to kind of give a summary of what we've talked about, and then to talk about some other obligations for the business when there is an injury.
Absolutely. Thank you, Joel. So yeah, quickly in summary, just remember that there is always a presumption of employment, and that presumption can only be challenged by the facts of the actual working relationship. And even if you aren't managing those relationships directly, you may still have an obligation to ensure compliance if you are part of the chain of liability. So being proactive, having processes in place, and being diligent with documentation and the details are the best way to protect yourself and your workers. So we'll now finish up the presentation just with some more things to remember if an injury does occur. Right, assuming everyone is compliant and doing things right, an employer still has obligations after an injury has occurred, and should build this information into any post-injury action plan or process that you might develop. So most importantly, in an emergency, seeking immediate medical care is all that matters. That's priority number 1, always. In less urgent situations, you want to make sure you provide your worker with a designated provider list of providers that they can select from. And then depending on the situation, you must report incidents to your insurance company within the appropriate amount of time. So missing these required timelines can affect the claims process. So it's important to know them and then understand what must be done by when, depending on a situation. We have a great employer guide that is published on our website, and I encourage each of you to download it. It really gives a thorough and expansive overview of everything an employer should know as a baseline about this process, at least to start. On one of the last slides, we're going to have a link to our publications page, and that has the employer guide in addition to a number of other really great resources. So like I said, the publications link is a little bit further on at the end of the presentation, and I encourage you to take a look at that. After an injury has occurred, you should also always investigate the accident and use that information to improve workplace safety. And you should always maintain communication with your worker and your insurance carrier throughout the process. And that's not just to make sure that the process is going as smoothly as possible, but maintaining that communication with a worker can really go a long way in helping them get back on their feet, get back working. You might be able to offer them like a modified job duty where they might not be able to work in their regular capacity, but they can work in a modified way. And even doing that goes a long way to helping somebody recover. So those are both really great things to do. And the second bullet point there, the investigating the accident, that's an important piece, and really that could be its whole other topic in discussion. So that really ties into what I alluded to at the beginning. But another program that we offer here at the Division of Workers' Compensation is called the Premium Cost Containment Program. And so this is an excellent resource for employers. And maybe we'll be able to do another presentation in the future, but at the very least, we have linked information for the program there in the slide deck. But to give you a quick overview, the PCC program is a free program that offers resources and guidance from industry professionals and risk management experts to help you develop a personalized safety plan and then maintain that workplace safety plan as you go through your ongoing operations. Now, employers who are certified in this program can receive up to 10% discount on their insurance premium. More significantly, every injury avoided saves money in the long run too. It's like car insurance. The less accidents you have, the lower your premium stays. And I know Joel alluded to that as well. But most importantly, as we've said before, it keeps workers healthy and able to provide for their families. And demonstrating your commitment to safety for employees, and then having a certification is sort of to validate that like present and tangible program and safety prioritization in the workplace. It goes a really long way to attracting and retaining talent, cultivating a healthy work culture, and just improving productivity and overall employee satisfaction. And many of you might already have safety programs in place, and maybe with small tweaks and certain types of documentation, you could potentially see that savings, that certification, and that validation with little or no change to what you're already doing, just by doing what you're doing and putting it within the parameters of the program, documenting it as you need to, and working with those industry professionals who work with the program, maybe to even find some areas for improvement too. So potentially more to come on that topic, but at the very least, please go and check out that link in this slide to learn about the program and maybe how you can save some more money and really formalize and maybe improve what you're already doing to prioritize safety for your employees. All right. So I hope you found some of this information useful. And we really do appreciate your engagement and taking some time this morning to learn a little bit more about this topic. If there are any questions about this or anything else related to workers' compensation, we'll do our best to answer them. And if we're unable to, we'll find somebody else who can and make sure that we connect you with that person. So thanks again for your time. And if there's anything, any questions or otherwise, we're happy to hang out and talk about those.
Yeah, thank you so much, Alex and Joel. That was a lot of information, but really good information. I really appreciated those case studies that actually, talked about the different layers of, okay, level 1, level 2, level 3. And clearly, it's really a powder keg, if you will, if you don't, if one level doesn't work and where the liability falls. That was really interesting. For those of you who haven't been monitoring, we have posted links that they have referenced in this program into the chat. And of course, we will be sending an email after the program with the actual slides that you saw here today. And it does have those links. But, just in case you were following along, they have the links are here in the chat. If anyone has any questions right now, feel free to unmute yourself and go ahead and feel free to ask them. I know that Alex and Joel both have their email addresses posted on this last slide up here, so certainly they are willing to address your questions, should you have any, after today's webinar. Anyone have any questions that they'd like to share or inquire about? We'll just stay here for just a minute, and just want to make sure that you know, there's lots of free resources out there available, and you know, I know I learned some stuff. I'm a small business person myself, and I operate as a contractor with ACEC Colorado, in fact. So you know, I found some of those details to be especially pertinent, and I know that you know, the two-pronged approach and the various levels, you know, especially those expanded factors that, like you mentioned, the Colorado Supreme Court expanded some more of those factors even. You know, it's always good to kind of go through the whole list of you know, checklist of things, just to make sure that you are, you know, where you actually fall as an independent contractor or as an employee. So that's really helpful. I also found that it was, you know, really interesting, the level of the case in the MDR roofing, that it was, you know, talking about, you know, the property owner, you know, and the contractor, and then the subcontractor, and the timing of all of the, you know, the premium getting canceled, you know, the policy being canceled, the employee getting injured, the reinstatement, and then ultimately all three parties were found to be liable in that situation, even though, you know, the top two really weren't aware of what was happening. So, you know, that's a really good caveat that everyone should be worried about. And you're right, it was a very expensive process for all of them, I'm quite sure. Well, if no one else has any other questions today, I'll go ahead and, you know, just kind of wrap up with a few housekeeping announcements. So again, you'll get a link, an email with an evaluation, and also a link to download these slides, which I think were really helpful. Also want to let you know ACEC Colorado has some events coming up that you may be interested in. First of all, on Thursday, November 9th is our annual Engineering Excellence Awards luncheon. This year we're hosting it at the Hyatt Regency in the Tech Center. Hope that many of you, especially if your teams have submitted an entry in our program, will be able to join us there. You can register online from our website. That's acec-co.org. We also have some other functions coming up. We're actually going to be launching our call for presentations for our annual conference in April in Westminster. So be looking for communication from us about that. We're also hosting our ethics workshop coming up in December as well. And so we will be pushing out some information to all of our members about those functions. And certainly want to make sure that if you have any questions, feel free to reach out to ACEC Colorado. Visit our website at acec-co.org. Unless anyone has any other questions, I want to thank you again for joining us today, and hope you have a great rest of your day. Thanks again.
Thank you for having us.
Yeah, thanks for having us.
Our pleasure, really. Thank you.